for being here. So I wanted to show you this, and then we'll look at the documents. You're like, we love the docket. Is the docket here? Welcome, welcome. If you are here, welcome to the stream. If not, don't worry. Then you'll see it later. Okay. Now, here they say Bryan Kohberger's termination letter from WSU mentions an altercation with a professor and a lack of professionalism. As you know, recently in this case, there's been a lot of like leaked, brand new information, shocking, sensational, all that stuff. And it does start to worry me a little bit because I do wonder if it is going to create reasonable doubt. It just takes one juror. I would hope that, of course, they would find an impartial jury and that everything will be fine. But I'm like, damn, there's a lot of new leaked information coming out all the time. And it's actually getting worse and worse and worse. I don't know if you guys have seen the new leaked audio, supposedly from DM, one of the surviving victims, or the one who witnessed the bushy eyebrows. I mean, it's interesting to listen to, but I'm like, damn, again, low sodium diet. PD, thank you so much. You say Grizzly True Crime, best in True Crime. Greetings to Lizelle, Dita, and Fury. They have been so stressed behind the scenes, you guys. If you don't know who Lizelle and Dita are, Fury's my cat. Go to my second channel. It's called G&T, and you will meet them. Okay, so Marilyn from my second channel. Yeah, Marilyn, you guys, has had to intervene today. Okay. So, yes. Okay. So let's look at this because this is in response to all these claims that came out of, we'll read it here, it was on News Nation's Banfield saying that he was fired. And then I see a lot of people on Twitter saying there's no way he was actually fired. It wouldn't be public like that. There's some Grizzlies that have emailed me that also have connections that work there at WSU. And they're like, that's just not how it would work. So I'm just like, again, low sodium diet, right? No, low sodium diet. Okay. So, Idaho killing suspect Bryan Kohberger was allegedly fired from his position as a teaching assistant at Washington State University, and a termination letter provided to News Nation may give new insight into the university's decision. Kohberger, 28, a criminal justice graduate at WSU, is accused of killing 4 undergrad students of the nearby University of Idaho in their off-campus rental home in Moscow, Idaho, in November. So November 13th, 2022. If you know nothing about this case, please check out my playlist. I'll link it below for you as well in the description box, in the pinned comments. I'll timestamp everything for you because you may just want to catch up there, especially when I do those like timeline recap videos, right? The termination letter obtained exclusively by News Nation's Banfield was dated December 19th, or more than a month after the killing. So that's also why I'm like, grain of salt, because more than a month later, he was fired. But I guess when John Kelly, a criminal profiler, was on the show just a few days ago, we were talking about this because could it have been, adding to if Bryan, remember, he's innocent till proven guilty in a court of law. If he is the dude who did this, then could this have added to the rage he was already experiencing, being rejected from the police department as an internship, maybe then seeing this is a rocky road. Oh my word, I'm going to lose my office. I might lose my apartment. I'm going to lose this whole teacher assistant thing. It is interesting, but again, grain of salt. They said, Mr. Kohberger, I'm writing this letter to formally inform you of the termination of your teaching assistantship with the Department of Criminal Justice and Criminology effective December 31st, 2022, reads the letter. In keeping with the WSU Graduate Student Handbook Chapters 9G2 and 12E3, below is the list of events that led to you being deficient in the following contingency clause of your funding: maintaining satisfactory progress in fulfilling assistantship service requirements and duties. The complete list of events as described by WSU reads as follows. Okay. So, on September 23rd, 2022, you had an altercation with the faculty you support as a TA, Professor Snyder. I met with you on October 3rd to discuss the norms of professional behavior. On October 21st, Professor Snyder emailed you about the ways in which you had failed to meet your expectations as a TA thus far in the semester. As a result, on November 2nd, you see, November 2nd, and the murders took place on November 13th. Graduate Director Willits and I met with you to discuss an improvement plan, which you agreed to and I shared with you in an email dated November 3rd. We met again on December 7th, this time with Professor Snyder as well as Dr. Willits and I to discuss your progress and improvement plan. While not perfect, we agreed that there was progress. Okay. On December 9th, there was another altercation with Professor Snyder, in which it became apparent that you had not made progress regarding professionalism, and about which I wrote to you on December 11th requesting a meeting. We met on December 19th when I informed you of your termination as a TA for spring semester. I wonder if this Professor Snyder will be like a character witness at all at the trial, if it goes to trial. If he doesn't, for instance, get offered a plea deal and take that, I don't know. I don't think he will, but we just don't know at this point, right? So this is that article, right? And then they say here, WSU responds to the report that Bryan Kohberger was fired. Idaho student murder suspect Bryan Kohberger is no longer enrolled at or employed by Washington State University, where he was studying for a PhD in criminology, as he sits in an Idaho jail cell facing murder charges in the stabbing deaths of 4 undergrads. Mr. Kohberger does not currently have a teaching assistantship, and he is not currently enrolled at WSU, said Phil Weiler, the school's vice president of marketing and communications. But he used to, before police alleged he ambushed a group of students at a house in Moscow, Idaho, just a few miles away from the WSU campus. Mr. Kohberger received an appointment as a teaching assistant at Washington State University during the fall 2022 semester, Weiler explained. It is typical for students to receive a teaching assistantship or similar appointment as part of their PhD program. Okay. Yes, thank you. I see the mods are answering questions that I already addressed. Thank you so much. Mrs. Melissa says, gee, discreetly wave a white flag if he needs to intervene between Dita, Lizelle, and Marilyn. Thank you so much. Okay, Kohberger previously had a graduate student office. Remember that was part of the search warrant? Remember that? We've gone through the probable cause affidavit, the search warrant, the gag order, and then the Goncalves family attorney appealed that. And today we're going to look at the response from Bryan Kohberger, from his defense team, to that appeal. Okay? So they say, Kohberger previously had a graduate student office in the Wilson Short building, and as part of his studies was working as a teaching assistant. In response to a report of a letter stating Kohberger was fired after a meeting on December 19th, Weiler declined to go into specifics about the timing, citing the Family Educational Rights and Privacy Act. You see that? Which protects student records from public disclosure. That's where I worry. Like, is it even true? Is it true? Or who is the source leaking all this information, right? I wonder, especially when there's a gag order. I know the gag order, people remind me, it doesn't apply to WSU, any of the students there, any of the professors there. I'm just like, I just wonder, like, who is leaking information, and are they? In response to a report of a letter stating Kohberger was fired after a meeting on December 19th, Weiler declined to go into specifics about the timing, citing that, and I'm reading it again, the Family Educational Rights and Privacy Act, which protects student records from public disclosure. WSU has not publicly released any information regarding Mr. Kohberger's experience as a teaching assistant. So that's how they respond back. Okay. Former students have said he seemed preoccupied after the slayings and became an easier grader. Now, if you didn't know, if you missed all the other episodes, Bryan Kohberger, as a teaching assistant, was apparently grading students very harshly, but not just students, specifically female students. He graded them really harshly, and one even said he was mansplaining things. So there's definite anger towards women that we've seen throughout, like some very strange interactions, right? So, following a quadruple homicide just 7 miles away near the University of Idaho, a crime that police allege Kohberger committed, he continued classes and finished out the semester as both a student and a TA. In mid-December, with investigators looking for evidence against him, he drove home to Pennysylvania. On the way, on December 15th, police body cam video shows officers stopped him twice in Indiana, and he was only focused on 2 things: getting Thai food. Getting Thai food, and that SWAT incident that happened. Very, very odd small talk that, okay? According to court documents, Kohberger's white Hyundai Elantra was recorded on surveillance video in his hometown in Albrightsville, Pennsylvania on December 16th. 2 weeks later, a tactical team involving state police and the FBI arrested him at his parents' house there. Okay, now the rest we literally know. We know all the stuff, okay? So I'm not going to read all that again. Now, let's get into this, which is... Stand by. Let's get the document ready. this one. I'm going to read this one because it's 9 pages. The other one is 21 pages. I suppose I should start by showing you, actually. This is the 21-page one, okay? And so let's just show you like this. In the District Court of the 2nd Judicial District of the State of Idaho, in and for the County of Latah, State of Idaho plaintiff versus Bryan Christopher Kohberger. Yes, his second name is Christopher, if you didn't know. Kat says, driving across the entire country to get Thai food. Right. Listen, he was going for Thai food. Linda says, love documents. Me too, me too. Okay. So, State of Idaho, County of Latah. Right. I, William W. Thompson Jr., being duly sworn, do hereby state the following information is true and correct to the best of my knowledge and belief. I'm the elected prosecutor for Latah County and have served in that position for approximately 30 years. In that role, I am one of the attorneys representing the state in the above titled matter. The members of the Goncalves family who are represented by Mr. Shannon Gray are potential witnesses in this case, including a trial and or sentencing. Important to note, there are potential witnesses. Okay, so what I'm going to do is just, we want to just zoom out to show you. I just want to quickly do this. It's pretty long. Here they say memorandum of points and authorities relating to the non-dissemination order. So this goes into a lot of backstory detail, right? So what we're going to do is look at the objection, which is interesting, very interesting. Let's just do it like this. Can you see properly? Are you all good? Can you hear me properly? And you can see properly, right? Angela Bloom drove 6 hours out of the way for some Thai food. Sure did. Okay, so this is the new document. I actually haven't seen anyone yet with this document. The docket sent it to me. His name is Big E, by the way. Big E. The docket 71 on YouTube. And I just looked at this and I'm like, sorry, what? Does this mean he has a new attorney? What's going on here? Is he stepping up? Is he going to Ted Bundy our asses? Because I wouldn't be surprised. If he eventually, I mean, he's being all like sweet now, I just mean the way he's like smiling at the attorney, like, cool, everything's fine, sussing it out. But I just feel like someone with a criminal justice degree, someone who may have wanted to commit the perfect crime, might actually be someone who surprises us all and steps up before the trial. And I don't know who does what. But this is already interesting where they say this. Assigned attorney, Ann C. Taylor, public defender, right? Bar number. And J. Weston Logston, chief deputy litigation. Now, that's a new name we haven't seen on there before, not to my knowledge, right? Rob's like, oh no, representing himself. Imagine it. That's what I mean, by the way. If you guys are not familiar with why I say, is he going to pull a Ted Bundy on us? Maybe you could download my Ted Bundy audiobook. Yes, I wrote a book on Ted Bundy, Jeffrey Dahmer, John Wayne Gacy, and Eileen Wuornos. Then I came to YouTube. And I'm that type of person that's in or out. That's just how I roll. So I'm in YouTube here with you guys all the time, all day, preparing things. So I'm full-time YouTube here. And so, yes, if you want to listen to the audiobook that I narrated myself on Ted Bundy, then you'll know why I say that. But yeah, he basically wanted to defend himself. Okay. So that's why I say this. Anyway, the point is, assigned attorney. You see that? Now, I looked at it because I know there's been quite a lot of contention around the issue of Ann C. Taylor. We had the lawyer on the show. Excellent. Go check out his channel, The Lawyer You Know. And we also had Sunny Slaughter, a law enforcement and litigation expert, on the channel to talk about that. This, is it a problem? Is there a risk of a mistrial? Because Ann C. Taylor has previously represented 2 of the victims' parents. But that was in the past. And she's also the chief public defender, right? Okay. Yeah, you guys are like, love Peter. Yes. Okay. So I think Ann Taylor, she's continuing on. It's just there's another dude's name added here, J. Weston Logston. Now this is chief deputy litigation. This is some serious stuff. Yeah, devil's advocate. Do you have a new book in the works in all your spare time? Yeah, all that spare time that I don't have. Yes. Okay. So let's look at this. This is what I wanted to bring to you today. State of Idaho plaintiff versus Bryan C. Kohberger defendant. Objection to motion to appeal, amend, and or clarify non-dissemination order. So to summarize this, basically what's happening is the Goncalves family attorney is like, hey, You guys weren't clear on this. Are we allowed to talk at all? Can we do interviews? Can we do stuff? Because we need to say things. And I think they might also want to be responding to all this brand new graphic, sensational, hectic headliner information. They might also want to just have their say, but they can't. They can't. So they needed to clarify, are we part of this gag order or what? Like, what is going on here? Right? And so they say objection to motion to appeal, amend, and or clarify the non-dissemination order. So they are saying, let's listen. Comes now, Bryan C. Kohberger, by and through their attorney, J. Weston Logston, Chief Deputy Litigation, and hereby objects to the motion to appeal, amend, and or clarify the non-dissemination order filed by Shannon Gray as counsel for the Goncalves family. This objection is made on the grounds that the non-dissemination order properly requires Mr. Gray to abide by the clear requirement of the ethical rules of the state. Now, Idaho, not that anyone plays around, but they don't play around. You see it in the Lori Vallow case, Lori Vallow, Chad Daybell as well. There's been a lot of like secrecy, not to make a conspiracy. I mean, like they're being very hush-hush, even about these documents. There's lots of things being filed behind the scenes, lots of permission needed first from the judge before they release anything. It's very much like walking on eggshells in this case, right? So the court order is not violative of Mr. Gray's First Amendment rights. This is the argument. This is point one, right? In his memorandum in support of the motion for appeal and or clarification of the amended non-dissemination order, hereafter a memorandum, Mr. Gray contends that because his clients, the Goncalves family, are classified as non-party citizens, application of the court's non-dissemination order to him constitutes a prior restraint on his right to free speech under the First Amendment. In support of his position, Mr. Gray cites the fair trial and public disclosure provision of the ABA Standard for Criminal Justice, IRPC 3.6, as well as the precedent established under Shepard versus Maxwell, Nebraska Press Association versus Stewart, and Gentile versus State Bar of Nevada. The issue at hand may be summarized as follows. Whether application of a non-dissemination order to an attorney representing the family of an alleged murder victim constitutes an intolerable prior restraint on speech. The First Amendment prohibits laws abridging the freedom of speech, while the Sixth guarantees to the criminal defendant the right to a speedy and public trial by an impartial jury. Okay, so I know some of this might be like, is this boring or what? It's not boring to me, but don't worry, we're working through it. It's only 9 pages, right? Occasionally in conflict where protected pretrial expression threatens the impartiality of the jury. You see that? There are threats. Okay? The United States Supreme Court has determined certain parties' First Amendment rights may be limited when exercise of those rights would result in prejudice to the defendant, noting with his life at stake. That's interesting because they haven't filed for the death penalty yet. We haven't heard of that. The next hearing for Bryan Kohberger is June 26th. Okay. So they say, with his life at stake, it is not requiring too much that the defendant be tried in an atmosphere undisturbed by so huge a wave of public passion. Okay. And then Shepard, they're quoting here 384 US at 351 as a means of reducing the appearance of prejudicial material. And to protect the jury from outside influence, a trial court may prescribe extrajudicial statements by any lawyer, party, witness, or court official, and may also promulgate a regulation with respect to dissemination of information about the case. In either case, the cure lies in those remedial measures that will prevent the prejudice at its inception. Very nice. Okay. Everyone saying, love the mods. Yes, good job, mods. It's been a busy time, huh? Thank you so much. Okay, now one such measure is at issue here. As in Stewart, this court is presented with a confrontation between prior restraint imposed to protect one vital constitutional guarantee and the explicit command of another that the freedom to speak shall not be abridged. Okay. Unlike in Stewart, however, the regulation at issue is as to an attorney who may be subjected to greater limitations than could be imposed on the press. As the Supreme Court noted in Shepard, the courts must take such steps by rule and regulation that will protect their processes from prejudicial outside interferences. Neither prosecutors, counsel for defense, the accused, witnesses, court staff, nor enforcement officers coming under the jurisdiction of the court should be permitted to frustrate its function. Collaboration between counsel and the press as to information affecting the fairness of a criminal trial is not only subject to regulation, but is highly censurable and worthy of disciplinary measures. Thank you so much. Okay. So they say this holding was expressly upheld in Gentile, wherein the Supreme Court found the speech of lawyers representing clients in pending cases may be regulated under a less demanding standard than the established for regulation of the press in Stewart and the cases which preceded it. Lawyers representing clients in pending cases are key participants in the criminal justice system, and the state may demand some adherence to the precepts of that system in regulating their speech as well as their conduct. Gentile. Okay. In an attempt to exclude himself from these holdings, Mr. Gray, who's the Goncalves attorney, argues that because his clients are not parties to the case and therefore are not subject to the order, he too is due an equal measure of deference and exclusion. The weight of authority is contrary to this position. In Idaho State Bar versus Tapp, the Idaho Supreme Court made clear that courts must strike a reasonable balance between the right of free speech and the state's legitimate interests in preserving the integrity of its judicial system. In reaching this conclusion, the Tapp court relied upon the Gentile decision, which, in the court's words, balanced the state's interest in assuring fair trials against the free speech interests of attorneys. Thus, a case associated speaker's status as a lawyer alters the degree to which their speech is protected. This lawyer versus non-lawyer distinction is recognized broadly elsewhere, even in cases where the speaker attorney claims not to be involved with the case in question. In Good 821F and all kinds of numbers, the Fifth Judicial Circuit Court of Appeals considered whether an attorney who routinely communicated with and occasionally passed notes to the defense could be sanctioned for violation of a non-dissemination order. And the Louisiana Criminal Trial Publicity Rule 1, because he was not a lawyer associated with the defense or trial participant, application to whom, Good argued, the local rule was limited. Rejecting Good's argument, the court relied upon Gentile's own language that because associated lawyers have special access to information through discovery and client communications, their extrajudicial statements pose a threat to the fairness of a pending proceeding, since lawyers' statements are likely to be received as especially authoritative. I can agree with that. I agree, right? So, are we all coping? Are we good? Let me just quickly check something. I'm glad all the construction noise also stopped. That's good. Okay, no, we're good. So this makes sense why they're saying he can't. The lawyer, Goncalves' lawyer, can't just talk. All right. Further, the 11th and 2nd Circuits have interpreted the heavy presumption against constitutionality described in Stewart as being unique to prior restraints directed to the press and suggested that the Supreme Court's Shepard holding as suggesting a restrictive order limiting extrajudicial commentary of fair trial participants as an alternative to a prior restraint on the media. The News Journal Corporation versus Foxman, where lawyers representing clients in pending cases may be regulated under a less demanding standard than that's established for regulation of the press. As in Good, Mr. Gray has special access to information via his clients. Oh, yes. Okay. Dissemination of information forbidden by the court's order would be deemed authoritative as a result of this access, and Mr. Gray's status as an attorney, and therefore would endanger the jury's impartiality. The court's exemption of Mr. Gray's clients from its order effectively answers Mr. Gray's First Amendment concerns, while its continued application to him accounts for his apparent authority and special access to facts. Not facially vague, this was point number 2, not facially vague, nor vague as applied to Mr. Gray's circumstances. Mr. Gray then argues that even if the court may order him not to disseminate information to the press, because the court's order mirrors the language of IRPC 3.6, It is vague on its face and as applied to his circumstances. First, IRPC 3.6 is in no way vague on its face. It's such a weird expression. No way vague on its face. Okay, welcome to everyone who's new here. So they say here, now, it's in no way vague on its face. Mr. Gray's argument on this point is premised on a faulty understanding and misreading of the Gentile holding. In Gentile, the Supreme Court expressly stated, "We are not called upon to determine the constitutionality of ABA Model Rule 3.6, but only Rule 117, as it has been interpreted and applied by the state of Nevada," Gentile, right? Moreover, the Supreme Court held nothing inherent in Nevada's formulation of the trial publicity rule fails First Amendment review. But as this case demonstrates, Rule 117 has not been interpreted in conformance with those principles by the Nevada Supreme Court. All right. Gray's assertion that the Gentile court held that the wording of Rule 3.6 and 3.8 was unconstitutionally vague is simply wrong, because Gentile only found that Nevada's rule was unconstitutional as applied. If you guys missed the whole gag order readout, we've done that before. Okay, so I hope you'll go check out those episodes. This is, as we say, an objection to that appeal, meaning no, they want the gag order to remain in place, right? Because Gentile only found that Nevada's rule was unconstitutional as applied, that decision does not mandate a similar finding when evaluating IRPC 3.6. To the contrary, the Supreme Court's express finding that nothing inherent in Nevada's rule failed First Amendment review indicates that the same conclusion is appropriate with regard to IRPC 3.6, which, as Mr. Gray himself states, is similar in wording to ABA Rule 3.6. Mr. Gray's argument that IRPC 3.6 is unconstitutionally vague as applied to his own circumstances is also faulty. In Gentile, the Supreme Court found that one central point must dominate the court's as applied vagueness analysis. This case involves political speech. At issue here is the constitutionality of a ban on political speech critical of the government and its officials. Welcome to all the new members. Okay, while it is true that Mr. Gray and the Goncalves family have criticized the police in this matter in the past, since Mr. Kohberger's arrest, their statements have been focused on him. Okay. C. King 5, father of Idaho murder victim, says Kohberger was overwhelmed in court. Oh dear. They're actually they're linking it here. They're like, oh, they're clapping back now. Okay. Additionally, at issue in Gentile was the confusion created by the safe harbor exception for statements by the defense about the defense. Mr. Gray has essentially agreed his client is not a real party to this action and has nothing similar to a defendant's interest in sharing their defense with the press. Thus, the vagueness found in Gentile is inapposite to his concerns. Are you still following us? Welcome, everyone. Welcome. Angela, thank you so much. Angela McDermott, really appreciate it. Okay. So, 3. As an attorney, Mr. Gray cannot claim vicarious exemption from the rules of professional conduct and it is therefore bound by IRPC 3.6. Finally, Mr. Gray asserts that he is allowed to relay to the media any of the opinions, views, or statements of those family members regarding any part of the case, regardless of the rules of professional conduct, because it would place an undue burden on the victims' families if the attorney whom they have retained to represent their interests was prohibited from serving as their spokesperson to the media and other parties in transmitting the victims' families' thoughts and opinions. This assertion of vicarious exemption from the rules of professional conduct is plainly baseless. Besides being entirely inconsistent, we can see we're on page 7 out of 9, right? Besides being entirely inconsistent with the above provided precedent, Mr. Gray's position on this issue is contrary to the long-held acknowledgement that even outside the courtroom, lawyers in pending cases are subject to ethical restrictions on speech, which an ordinary citizen would not be. Thank you so much. And Richard said, Lizelle is sewing hoodies herself. Yes. Okay. And so we're going now down to page 8 almost here. They say, such has always been the case, as membership in the bar is a privilege burdened with conditions. Theard versus United States. Mr. Gray's representation of they spelled that wrong, but Goncalves family does not entitle him to the same degree of freedom of speech they enjoy as ordinary citizens. Further, Mr. Gray makes clear that if his motion is granted, he will comment on the case and other issues surrounding the investigation pursuant to Rule 3.6. What portion of Rule 3.6 Mr. Gray invokes here is an open question. Insofar as the rule addresses Mr. Gray's intended subject matter, it expressly identifies it as a subject more likely than not to have a material prejudicial effect on a proceeding, particularly when they refer to a criminal matter or any other proceeding that could result in incarceration. All right. Okay, are we all understanding? Are we good? That is a nice thought, exactly. Ma'am Nan says, my heart goes out to the family and friends of the victims. Yes. Now, Mr. Gray argues that he will not be offering up his own opinion regarding the facts surrounding the case, but rather only serving as his client's spokesperson, conduit to the media and other parties in transmitting the victims' families, thoughts, and opinions. Far from mitigating the already tenuous nature of his argument, this signal of intent again places Mr. Gray at odds with Rule 3.6 and Gentile. The court has already exempted Mr. Gray's clients from its order. So good to know as well. Okay, the court has already exempted Mr. Gray's clients from its order, adequately preserving their First Amendment rights. To extend this exemption to Mr. Gray would function solely to grant potentially prejudicial statements the weight recognized as a danger by the Gentile court on a subject the rule distinguishes as already extremely susceptible to prejudice. If Mr. Gray truly intends only to voice his client's thoughts and opinions, then the court's previous exemption has already cured the supposed First Amendment infirmity. Mr. Gray's clients may voice these thoughts and opinions themselves, as they have clearly been doing. The sole effect of maintaining the court's order in present form is the continued operation of a remedial measure that prevents prejudice at its inception. Mr. Gray is bound by the rules of professional conduct, and the First Amendment does not excuse him from that obligation. Dated this 8th day of February 2023, and that today's date is the 11th. So it was dated then, and I think it only came out yesterday. So, yes. N.C. Taylor, Public Defender, Kootenai County, did I say it right now? Kootenai County Public Defender, and also by J. Weston Logston, Chief Deputy Litigation Assigned Attorney. Let's just see this. Haley says, I can understand the family wanting to be able to speak, but they might end up as witnesses, so they need to protect the case. Exactly. All right. Okay, we're going to break it down with an article. That's what we do. We read the law. We read the law here. And for those of for those of us who are not lawyers, and we do not have the lawyer, with us right now, so we're gonna pick his brain. We're going to read an article afterwards to be like, what? But basically, Kohberger and his defense team want the gag order to remain in place so that the Goncalves family and their attorney cannot speak through their attorney just to the media to respond to whatever and share their opinions on Kohberger or what happened or maybe the surviving victims or any of that. Okay. So, Lady Lex, thank you for becoming a member. And Sparkly Little Chicken. I always like saying your name. Sparkly Little Chicken. Thank you so much. I really, really appreciate it. Now, someone in the chat said, gag order issued to prevent prejudicial publicity is causing prejudicial publicity, in my opinion. Oh, gag orders are supposed to be narrowly tailored, and they claim it is, so we'll see. Odd, right? Like, I just mean it's like, whoa, this case it's very high profile. Now we're at the end here. We're at the end. Very high profile, lots happening, and lots of everybody, we need to stay disciplined, patient. The next hearing is June 26th. Angela says, break it down here in Grizzly Town. Haley says, fangirl moment, you read my comment. And again, that's twice. Okay, so they say Goncalves family to testify against Bryan Kohberger amid judge's gag order. Okay, let's see what they say here. Prosecutors, okay, sorry, I must make it bigger for you. Prosecutors said they plan to call members of Kaylee Goncalves' family to testify against accused killer Bryan Kohberger and filed a motion to challenge an opposition to a judge's gag order. The members of the Goncalves family, who are represented by Mr. Shannon Gray, are potential witnesses in this case, including at trial and or sentencing. Latah County Prosecutor Bill Thompson wrote in the brief affidavit filed Wednesday. Judge Megan Marshall imposed a gag order on January 3rd for attorneys on both sides, which limited what they could share with the media. The judge later expanded that order to attorneys representing the victims' families and witnesses. Okay, so initially, the gag order was for what the attorneys could share on both sides. Prosecutor, defense, attorney on both sides, which limited what they could share with the media. The judge later expanded that order to attorneys representing victims' families and witnesses. Right? Welcome to membership, Cynthia Gaines. And everyone who is, if you are joining membership, just know that slow mode does not apply to you. Okay, so they say Gray filed an appeal against the gag order last week, arguing that it was unconstitutional and vague. As attorney for the victims' families, I am allowed to relay to the media any of the opinions, views, or statements of those family members regarding any part of the case, he said. Let me know what you guys think about all this in the comments. I'd love to see. And then, Ann Taylor, Kohberger's public defender, also filed an opposition to Gray's objection against the gag order. If Mr. Gray truly intends only to voice his client's thoughts and opinions, then the court's previous exemption has already cured the supposed First Amendment infirmity. Mr. Gray's clients may voice these thoughts and opinions themselves, as they've been clearly doing, Taylor wrote in her opposition. The sole effect of maintaining the court's order in present form is continued operation of a remedial measure that prevents prejudice at its inception. Do you guys agree with this or no? Rob says sending love and support to the victims' families. Yes. Caroline says sometimes people need to be protected from their dang selves. B says, just as I started to think this case is going to be hush-hush for months, more info is released. Thanks so much, G, for presenting the info with compassion, integrity, and in the spirit of truth. We want to fight, guys, for what is right? You know? I don't know. I just know when there's boundaries in place. I respect boundaries. When there's boundaries in place, then that's it. Okay, then it's like, oh, dear. You know, they're challenging the boundary, basically. Like, nope, you can't speak. You can't speak to the media. And they're like, why? The attorney's like, we want to speak to the media, but I don't know. Right now, maybe it's not such a great idea, right? And as we can see, whoa, on the YouTube streets and Facebook and Reddit and everywhere, there's a lot of stuff being released lately, one after the other, you know? From graphic details to the Bluetooth speaker possibly being connected to Bryan's phone, which is just real. That's just pure speculation. There's no fact to that, right? To some kind of leaked audio of a dude that is speaking about DM, the surviving victim, and all kinds of stuff, and saying it contradicts the probable cause affidavit. Wow, that makes a lot of just even public doubt, right? Ma'am Nan says, Gisela K, you deal with such gruesome crimes. Kudos to you for your strength. Oh, thank you so much. And Marlena says, I can't imagine what the family's going through, but I think in order to get justice for all these victims, everyone should stay quiet. Yeah. Diane says, we don't need mistrial, so have patience. Mm-hmm. We don't have a trial date yet. We just have the next hearing, which will be June 26th. Yes. CN, red flag, says, I respect boundaries. Boundaries are there to protect us. Exactly. Okay. So the sole effect of maintaining the court's order in present form is continued operation of a remedial measure that prevents prejudice at its inception. Kohberger remains in Latah County Jail in Moscow, Idaho, under a no-bail hold and is scheduled to appear back in front of the judge on June 26th. He's facing 4 counts of first-degree murder and a felony burglary charge. The 28-year-old is accused of murdering Goncalves and 3 others. I mean, I wish they would just say, like, it is and 3 others, but Kaylee Goncalves, Madison Mogen, Xana Kernodle, and Ethan Chapin on November 13th while they slept at an off-campus home on King Road where the woman lived. The former Washington State University graduate student was arrested at his family's home in Pennsylvania in late December. Okay, so those are all the updates, you guys. That's what we have now. Tammy says gag means gag. Healing Frequencies Music says any of us who live in North Idaho could be on this jury. A gag order should be in place. Yes, okay. Moon Beamer says, I think the gag order should stay as is. Any change could compromise the case. Okay, I'm just reading some of your comments here quickly. Oh, yes. Oh, wow. Okay, Lee says, I'm a victim and my case isn't going to court until April 2024. Things just take forever. I am very sorry that you're a victim of a crime. And yeah, things take time. I mean, we see it with Lori Vello and Chad Daybell. That's taken some time. That's also in Idaho, you know. So things do take time. The legal process takes a lot of time. There's like appeals that happen and, you know, delays. So even everyone's saying, okay, the hearing's in June and when's the trial? July? Is it December? It might even be, we don't know. It might be 2 years from now or more. We don't know. Could take a while, right? We have to be patient. Okay, so JJ says, just joined. Did he get a new attorney? He has been assigned. And well, put it this way, like this. That was pretty much a question I had, but it says it here. And someone earlier in the chat who was here before the stream started did help clear this up a little bit, where they say, look, assigned attorney, Ann C. Taylor, public defender. And now there's a second name there, J. Weston Logston, chief deputy litigation. And it says comes now, Bryan C. Kohberger, by and through their attorney, J. Weston Logston, chief deputy litigation. It's got a head honcho. First, he had the chief public defender. Now they're listing here J. Weston Logston, chief deputy litigation. Okay, so we've got that. Now, Angela Santos says you can't have a mistrial from media information. Jurors determined from evidence in court only. Family must be allowed to speak freely. Yes. So if you're just joining now, we were looking at this document and basically Bryan Kohberger, initially it was Ann C. Taylor, the only attorney assigned to him. Now there is a co-counsel, which is J. Weston Logston. So it's not that Ann Taylor's not involved anymore, not representing anymore. He doesn't have a new attorney. It's not a change of attorney. It's adding a co-defendant, a co-counsel, sorry. Co-defendant, a co-counsel. That's not the right word, co-defendant, a co-counsel. Yes? So we've got Ann C. Taylor, public defender, and J. Weston Logston, chief deputy litigation. Okay, so we've got that. All right. If you today see a lot of comments being deleted, I'm not able to do all of this and see exactly what's happening there, but I think mods are just dealing with some troll comments, you know. Yes, Pascal's in the house. What is up, Pascal? We're working hard over here. You guys always, the Grizzlies all love it. Always say working hard. And it was from when Pascal was on the show during the Naomi Irion case coverage. And he was like, that's a hard 42, right? It was a hard 41. Now I think it's 42. And so that stuck. The lingo stuck. I love Pascal's lingo. Welcome, Pascal. It's lovely to see you here. You can see all the Grizzlies are very excited as well. So yes, guys, we were just looking at some new documents today where Bryan Kohberger now has two defense attorneys, Ann C. Taylor and J. Weston Logston, the chief deputy litigation. He's probably going to need it because he's got the chief public defender and the chief deputy litigation. Wow. He's got some heavyweight attorneys there, huh? But he's going to need it. So that's what we've been looking at. Let me just quickly see if I type in Bryan Kohberger, if there's any other news right now. I always say Southwest. Is it Southwest? SW 4x4 Explorers. Do you think Ann Taylor felt creeped out by BK and wanted a mail with her? Kind of curious. I mean, I haven't thought about that, but I'm kind of curious too. I don't think that she would feel creeped out as a chief public defender and then say, "Oh no, I need a male. I need a male to help me on this case." I think she's a very strong lady and would not necessarily need that. I don't think it's that. If I had to say my personal opinion, I think it's more just like, "Oh damn, we need to. I don't know. We need another person on this team, right?" Okay. Yeah, no, there's pretty much there's not really other news beyond that for now. Like actual factual news right now. Okay, so thank you. And you're like, Pascal. I hear you saying that. Pascal. Yes. And Devil's Advocate says public defender doesn't not equal cheap. Okay. Yes. So uh Angela says, I hope you will cover Daybell G. I'm so confused on that case. I do have a playlist on that case, and I've made a whole chart. You know my presentations? I made the whole chart. So even if you watch that today, you will be able to be caught up on who's who and what happened and when. There's a whole timeline there and everything. So just check out the playlists on my channel. You'll see it there. Okay. So yes, of course. Molly says it's very common to have more than one public defender. It is very common. This is not unusual. Okay. Becky says, no, don't go, G waffle. Oh, you can tell. I'm gonna go soon. Huh? You could tell. Let's just quickly look at Bryan Kohberger on Twitter, because there's a lot of updates that happen there as well. Okay, we've just got articles and things. I think we're good. I think we've covered everything right now. So Dean says, when is the next live, G? We actually had one earlier. So if you missed that one, that was on the Nicola Bully case. There might be another live tomorrow. I'll see what news there is. So sorry, I was laughing here at someone said Nutburger. Nutbutt? We got the Nutbutt emoji. Yes. Slenderella says, I wonder what BK is thinking right now. He's probably thinking he doesn't want more fan letters, I would assume. I think he's got a lot of like female fans now. It's quite odd. Male and female. Anyway, it happens in every case. So, Petey said, don't go. Time for PJ party. I think it's time to hydrate. Take a breath of fresh air. What do you guys think? Yes, the Valo Daybell case. Exactly. Well, thank you all for being here. I really appreciate it. Mods, thank you so much for all the hard work. I know today was very hectic. We had 2 streams, one on the Nicola Bully case. I'm following every single update I possibly can in the case. Go check it out. What we were looking at was her partner, Paul Ansel's interview with Channel 5. So you can go check that out there. And yeah, if you are a member or patron, make sure you, in general, always check the community tab, and definitely on Patreon, always check your inbox, because you never know when we might just have a little live stream and just chill out a bit, just chat with a G&T, literally, and just relax a bit. Okay, so thank you so much, everyone. Yes, thank you for sharing the link. And Dean says, Gisela rules. Really appreciate all of you. If you haven't yet, now in the outro is your time. If you're a lurker, we love lurkers, okay? To subscribe, hit the bell. Make sure you leave a comment. Please keep it kind and respectful. We say keep it grizzly over here. That's our standard. Kind, respectful. Be kind to everyone, okay? And I will see you in the next one. Let me just turn this off quickly. I'm going to turn slow mode off now, so you can just type wildly and subscribe any duration. If you subscribe for 1 second, you are a subscriber and you are a grizzly. And welcome to Grizzly True Crime. All right, everyone. I will see you whenever the next one is. If there's any other news or anything, I'll keep you posted. Okay, everyone. Bye.